Allison Iwoma, come up, ma'am. Good morning, Mr. Osborne.
Hey, how you doing?
What's new?
Sorry?
What's new?
Oh,
Here we go.
just, the same old is new.
I feel you. I feel your pain. You are Miss Iwoma.
Sir.
Ma'am, you are charged with driving while intoxicated. Second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge.
Okay.
On February 25th, officer dispatched to a minor crash with a disturbance at the 1000 block Upland Drive in Harris County, Texas. The officers made contact with two witnesses. The second witness stated she was driving her Lexus north on Upland Drive when the defendant, the sole occupant of the vehicle, was driving her black Camry south in the northbound lane. The witness stated she slowed down, honked to alert the defendant, and crashed into her car in front of him while going north. The first witness stated he was in the southbound lane and was stopped waiting to enter the service road.
All right, people, let's jump straight in. A sleepy courtroom morning? Not this one. Allison Iwoma walks in, charged with her second DWI. This isn't just paperwork, we're talking jail time, a $4,000 hit, and a judge who isn't playing. This isn't traffic court. It's real. It's serious. And it's all about to erupt.
And the defendant driving her Camry struck the Lexus, and after the two motor vehicles crashed, the defendant swerved right and then ran into the back of the Chevy Blazer the first witness was driving. The first witness stated the defendant appeared to be looking down like she was slumped over, and the first witness approached the motor vehicle and the defendant appeared drunk. The defendant tried to drive off and the first witness was telling her to stop and wait. The second witness corroborated the first witness' statement and stated she could smell a strong odor of an alcoholic beverage and that the defendant was drunk. The officer made contact with the defendant, and the defendant stated she was driving her car, had left home, and was on the way to the hospital for her ulcers. The defendant stated she was on the right lane going south, and a lady in an SUV was going north in her lane. The defendant stated she swerved over and hit another car. She tried to exchange information and get off the roadway, but was not trying to leave the scene and only wanted to move the cars into the parking lot on the west side of the road. The officer observed a moderate odor of an alcoholic beverage, glossy eyes, slurred speech, and swaying. The defendant was within normal parameters regarding her vital signs per Houston Fire Department, and standard field sobriety tests were then conducted. HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and consented to blood.
The crash report rolls in. Witnesses say Allison came in hot, driving the wrong way, swerving, smashing into a Lexus, and then rear-ending a Chevy Blazer. Eyes glossy, speech slurred, she looked slumped and stunned. And when they confronted her, she tried to bounce. But the alcohol didn't let her blend in.
All right. So we have a DWI here. Any more DWIs anywhere else? If you run around and say, Steve, please.
She only had a previous out of 2022 here in Court 5, but that's the only one, Your Honor.
Does she have a valid Texas driver license?
It's not eligible, Your Honor.
It's not eligible. I want to make something perfectly clear to you, Ms. Iwoma. I'm ordering you as a condition of your bond not to drive any vehicle whatsoever for any reason unless you have a valid Texas driver license and liability insurance. I'm also placing a restriction on your license that you're not to drive any vehicle that's not equipped with an ignition interlock. I'm sending notice to DPS in Austin so that every single police officer knows if you're caught driving a vehicle and it doesn't have an interlock in it, they will arrest you and put you in jail. Do you understand? And then I'm going to revoke this bond here as well. You will be signing an affidavit with me today. Counselor, did you want to add something?
Manage the law. That's incorrect. The cop did not say moderate. He said mild odor of alcohol.
Sure.
Yeah, Judge,
Now hold up, things heat up fast. Officers said she reeked of booze, couldn't stand straight, failed multiple sobriety tests, and still tried explaining it away as a hospital trip. No, ma'am, no excuses. The judge drops the hammer. No license? Then no car, no wheels, no mercy. Drive again, and it's jail.
a minor automobile accident and a mild odor of alcohol is not any kind of probable cause for intoxication. I believe what happened was the police officer noted she had a prior conviction and then jumped to conclusions and ran everything backward from there.
Well, we have witnesses who say that she's possibly intoxicated. They do field sobriety tests. The field sobriety tests indicate that she's intoxicated or potentially intoxicated, so that's when they do the blood test. This is just a mere probable cause hearing. We have someone who's got indicia of intoxication, slurred speech, odor of alcohol, crashes into 2 different cars, fails 3 different field sobriety tests. You've got 2 other witnesses that say that she's possibly intoxicated, who they're on the scene and see it. There's more than enough to go forward for probable cause purposes. Beyond a reasonable doubt, I don't know. That's why we wait for the evidence to come in. But I think that there's certainly sufficient probable cause to go forward. They say you don't have a license, so you may not drive at all for any reason. I don't care what your justification is. I don't care if
You don't move unless I say so, the judge fires. He orders breath tests, bans alcohol, and basically straps legal steel to her life. Why? Because she's officially a public risk. Doesn't matter if you're rescuing puppies or saving your grandma. Drive without permission, and you're going down. Simple. Clear. Savage courtroom reality.
Bambi has to go to the hospital, you need to save 30 kittens, a kid needs to go to the... You cannot justify getting into a car for any reason. Do you understand? This is an affidavit that you're going to be signing today, promising me you're not going to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months of jail and a $500 fine every time you drive, because it's an offense in and of itself. Do you understand? Because you don't have a license, because we're ordering you not to drive, I am now ordering you to obtain a portable breath test device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol. You're not to consume alcohol, illegal drugs, unprescribed controlled medication, and we will randomly test you as well. Now, good job on having a lawyer, because you have one. I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you because you're playing games and you're dodging phone calls, whatnot, I will issue a warrant for your arrest. All I'm trying to do is protect my city at all costs, and I will do it however I can. Do you understand? If that means putting you in jail because you become a public danger, I'm going to do it in a heartbeat. So for now, what I'm going to have you do is I will have you come up here, swear to us that you're not going to drive. Then I will get you to Victoria, where we'll have you sign a reset. You will get with Felicia for your bond conditions, and after that, you guys are free to go. All right?
Thank you, Judge.
Okay, guys. Thank you, sir. Please.
You can have the seats for you guys. You can actually see her.
So no priors? Roger?
Not to my knowledge, Your Honor.
Okay.
And so it's a drop.
Let me give you a cause number. You ready?
I got talk to
533
Yes, Judge.
02.
Now shift gears, new. Case, new drama. A mother-daughter battle explodes into violence. The daughter, packing her bags, loses it and allegedly shoves her mom into the wall. Boom, assault charge. The judge isn't having it. Protective order filed. No threats, no weapons, not even side-eye. One wrong move, and she's done.
And then I guess before we leave, if you can run an NCIC to see if there's any other priors.
I talked to Abigail, I'm sorry.
No problem.
Salgado,
Yes, sir.
ma'am, you are charged with assault of a family member. You are facing up to a year in jail and or $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
Yes, Judge. The complainant and the defendant are mother and daughter, and the officers were dispatched to a residence in Harris County, Texas, in response to a family disturbance. The complainant told the officers that she arrived home to find the defendant packing her things. The complainant began discussing the defendant's life choices, which led to an argument. The complainant tried to get the defendant to stay at the home, but the defendant grabbed the complainant by the shoulder and shoved her against the wall, causing pain.
Ma'am, I'm going to find that there's enough probable cause to go forward with your case. Do you guys have the rip done?
There is a rip on, Your Honor.
What does mom want contact with her?
My understanding, she's okay with contact.
She wants contact, Your Honor.
Is she here now?
No, she lives in a separate home. Since that incident, she's moved.
So I want you to understand something, Ms. Salgado. I'm now entering what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Gonzalez as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon. Do you understand? If you violate this court order, the state can and probably will file a violation of a protective order, and that is one of the worst misdemeanor cases that you can pick up. So just be nice. If you butt heads constantly, find another way. Go outside, do something else. But if you guys get into it again and there are threats made, you might end up back in jail. You understand? So this usually comes with a residential restriction that you cannot go back to the house. I will take this off. I am ordering you not to have any threatening or harassing contact with her. What is threatening or harassing doesn't matter what you think, it's what she perceives. So conduct in and of itself can violate this. You understand?
You speak out. Okay, I understand.
Do you mind filing another threatening or harassing?
Yes, Judge.
Please. So, bond,
Judge, we are asking for $100 pretrial bond. She has no history. Once she found out about the case, she hired us. We're here presenting ourselves and availing ourselves to the court's jurisdiction. I don't think she's a flight risk or a threat to the community.
response?
And just, there is no criminal history, and
Okay.
given the complainant's statement to us, we wouldn't be opposed.
Okay, so I'm with you. I'll set bond at $100,
Thank you, Your Honor.
and then I'm going to grant you a PR bond. That means that I'm giving you a free bond today. But understand that I'm going to protect my community at all costs. If I find that you become a danger to my community, I will revoke that PR bond, issue a warrant, and put you in jail. No more. You will not get any more. Do you understand? Now, because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them, and they will tell you if and when you have to come back to court. Okay? All right, so I'll have you sign a reset with Victoria. We'll have you get with Felicia for your conditions, and then you're free to go. Okay?
Judge, may we be excused briefly?
So, PR bond and $100.
Final warning delivered, straight up. No stalking, no drama, no, I didn't mean it. If mom says it felt threatening, it counts. $100 bond? Sure. But mess up, and the free ride ends. The judge is clear, protect the people at all costs. You step out of line? You vanish behind bars.